Hello everyone, I'm Nazarat Fatima. Welcome to LiveLaw. As you're aware, the President of India on December 25 gave her assent to the 3 new criminal code bills, which Parliament recently cleared. These 3 new laws, the Bharatiya Nyaya Sanhita, the Bharatiya Nagarik Suraksha Sanhita, and the Bharatiya Suraksha Sanhita will replace the Indian Penal Code, the Code of Criminal Procedure, and the Indian Evidence Act of 1872. In this video, we'll talk about the Bharatiya Nagarik Suraksha Sanhita, which has, among other changes, introduced the provisions of zero FIR, e-FIR and preliminary inquiry before the registration of FIR in certain cases. So let's first talk about zero FIR. Beginning with the zero FIR, let's first try and understand what this means. A zero FIR can be registered in any police station where information about a cognizable offence, which is where a police officer may arrest without a warrant, is received irrespective of its territorial jurisdiction. Thus, in other words, a zero FIR can be lodged at any police station irrespective of where the incident has taken place. After registering the FIR, the police station is then required to transfer the relevant documents to the police station which has the jurisdiction over the matter. The concerned police station then numbers the FIR and investigates the case. While Section 154 of the CRPC provided for the registration of an FIR, the corresponding provision for the same in BNSS is Section 173. It is important to note that a zero FIR is not a newly discovered concept in the Indian criminal law system. In an advisory issued by the Ministry of Home Affairs 2015, the government suggested registering zero FIRs for crimes against women. Not only this, even the judiciary has stressed the registration of a zero FIR in several cases. For instance, in the case of State of Andhra Pradesh versus Punati Rumulolu and others, the court held that any lack of territorial jurisdiction should not have prevented the constable from recording information about cognizable offence and forwarding the same to the police station having jurisdiction over the area in which the crime was said to have been committed. In another decision rendered in Satwendra Kaur versus Government of NCT Delhi, the Supreme Court held that even after investigation is over, if the investigating officer arrives at the conclusion that the cause of action for lodging FIR has not arisen within his territorial jurisdiction, then he is required to submit a report accordingly under Section 170 of the Criminal Procedure Code and to forward the case to the magistrate empowered to take cognizance of the offence. BNSS has now given a statutory mandate for zero FIR. Now let's come to e-FIR. Section 173 also provides for registration of the FIR electronically. However, the signature of the person giving such information is required to be taken within 3 days before the e-FIR can be taken on record. This provision has come as a major relief for women victims. This will help them not only prompt the registration of sensitive cases, but also help them in not repeat their ordeal while registering their FIR. In this regard, it may also be noted that the Parliamentary Standing Committee on Home Affairs, in its review report of the bill, acknowledged the positive impact. However, at the same time, the committee also opined that such online or electronic registration should be allowed only through modes specified by the state. If left unregulated, it would be technically and logistically challenging for the police. It would also be difficult to track and manage the multiple FIRs filed. Accordingly, the committee in its report recommended the insertion of as specified by rules after electronic communication to grant the government the authority to prescribe specific modalities for electronic FIR registration. However, the BNSS bill, as introduced in the Lok Sabha and now has been given assent by the President, did not include any such insertion. Coming to preliminary inquiry. Apart from this, Section 173, Clause 3 of BNSS has given statutory recognition to preliminary inquiry for cases punishable with 3 years or more, but less than 7 years. The same shall be conducted with the prior permission from an officer not below the rank of Deputy Superintendent of Police. Pertinently, the inquiry shall be carried out within a period of 14 days in cases where there exists a prima facie case. However, in cases where the prima facie case already exists, the officer is required to proceed with the investigation. For convenience, Section 173, Clause 3 reads as, without prejudice to the provisions contained in Section 175, on receipt of information relating to the commission of any cognizable offence, which is made punishable for 3 years or more, but less than 7 years, the officer in charge of the police station may, with the prior permission from an officer not below the rank of Deputy Superintendent of Police, considering the nature and gravity of the offence, proceed to conduct preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in the matter within a period of 14 days, or proceed with investigation when there exists a prima facie case. In this context, it's important to note that the Supreme Court, in its landmark decision of Lalita Kumari versus Government of Uttar Pradesh, had categorically held that the registration of FIR is mandatory if the same discloses commission of a cognizable offence. It held registration of FIR is mandatory under Section 154 of the Code if the information discloses commission of a cognizable offence and no preliminary inquiry is permissible in such a situation. If the information received does not disclose a cognizable offence but indicates the necessity for an inquiry, a preliminary inquiry may be conducted only to ascertain whether cognizable offence is disclosed or not. Thus, the scope of the preliminary inquiry was to ascertain whether the information reveals commission of cognizable offence. However, as per the new provision, the threshold for conducting preliminary inquiry is of prima facie case. According to Lalita Kumari, the category of cases in which preliminary inquiry may be made were matrimonial disputes or family disputes, commercial offences, medical negligence cases, corruption cases, cases where there is abnormal delay or laches in initiating criminal prosecution. For example, over 3 months delay in reporting the matter without satisfactorily explaining the reasons for delay. That would be all for this video. We hope you like our content. If you do, please like and share our videos. Also subscribe to our channel on YouTube and don't forget to press the bell icon for notifications. Thank you for watching.